Welcome to the final episode in the series on articles of clerkship. Today we will be discussing cession of articles, which occurs far more often than one would expect. The next episode will constitute the commencement of a new series, which will entail civil procedure and drafting amongst many other things, which we are very excited about. In addition to our Twitter page, we now also have a Facebook page, where we will discuss various subjects in great detail. Links to our Facebook and Twitter pages are in the description below. But for now, let's finish off our series on articles. Please take note of the usual disclaimer. What does it mean to cede articles? Simply put, to cede articles means changing your principal. In essence, you are terminating your employment with your initial firm and taking up employment at a different firm, hence the change in principal. The important distinction is that you do not restart articles, but rather continue with the service thereof just under a new principal. Cession usually occurs for a number of reasons, the most common being the following: extremely difficult principals, we've heard horror stories, unpleasant working environments, exploitative pay, better offers from other firms, lack of practical legal exposure, lack of learning on the job, death of a principal, insolvency of a principal's conviction of a crime, closure of a firm, and personal circumstances. There are a number of requirements to ceding articles, including the conclusion of a cession agreement, which we'll get into shortly. The parties to a cession agreement will be the cedant, who is your first principal, the cessionary, who is your new or your second principal, and the candidate legal practitioner, who is obviously you. When may articles be ceded? A practical vocational training contract, as we know by now is an articles contract, may, with the consent of the principal and the candidate legal practitioner concerned, be ceded to any other principal willing to accept such cession. As mentioned earlier, your articles contract may be ceded for a number of reasons. What are the formalities pertaining to cession? As a candidate legal practitioner, the Legal Practice Council needs to know of your every move. Therefore, the following are requirements for the valid cession of your articles contract. A cession agreement must be concluded, the registration of the cession agreement fee must be paid, and a letter by the cessionary requesting the LPC to issue a certificate of right of appearance to you in accordance with Section 25, subsection 5A or subsection 5B of the Legal Practice Act, if applicable. The cession agreement. A cession agreement must be drawn up, and every page thereof must be signed by all three parties, namely the cedant, cessionary, and candidate. The agreement must also be signed by witnesses. The cession agreement must, within 2 months of the date on which the service of the candidate concerned may have terminated with the cedant, your first principal, or within such further period as the court may on good cause allow, be lodged with the Legal Practice Council by the cessionary, the second principal, together with affidavits, firstly by the cedant, stating whether the provisions of the Legal Practice Act and the rules relating to service under the articles contract have been complied with during the whole term of service during which the candidate concerned was in the service of the cedant, and the date on which the candidate terminated their services with the cedant. And secondly, by the cessionary stating the date on which the candidate assumed duty with the cessionary. As per the aforementioned, if the cession agreement is not lodged within the 2 months period, the candidate legal practitioner will have to approach the court, which may allow the cession to be lodged with such further period on good cause shown. You don't want to place yourself in such a situation. A link to templates of the cession agreement, as well as the affidavits of the cedant and cessionary, can be found in the video description below. Payment of the registration fee. Prior to or simultaneously with the registration of the cession agreement, payment of the registration fee must be made to the LPC. The registration fee is, as of 2021, R345 VAT included. Payment can be made via EFT, so contact the LPC for the relevant bank details. We will not post them here. Take note of the reference to use when making payments. Should you make payment via EFT, proof thereof must be submitted together with the other Cession documents. The request for a certificate of right of appearance. Your new principal must request the LPC to issue a certificate of right of appearance to you in accordance with Section 25, subsection 5A or subsection 5B of the Legal Practice Act, if applicable. The request must be in writing and can usually be emailed through to the LPC. This must, however, be confirmed with them. We have placed a template of the written request to be made by your principal in the Google Drive folder linked in the description. What happens once I've registered the Cession agreement and lodged the supporting documents with the LPC? The LPC shall, on payment of such fee as may be prescribed, examine the agreement and the relevant affidavits, and if it is satisfied that the Cession is in order and it has no objection thereto, register the Cession and shall advise the attorney and the candidate concerned in writing of such registration. Cession in the event of your principal's death, mental illness, insolvency, conviction of a crime, suspension from practice, striking off the roll, or discontinuation of practice. The LPC may, in the event of any of the aforementioned circumstances or any other cause, direct that the articles contract concerned be ceded to any other principal willing to accept such cession, and all service completed under the ceded contract shall be effected for purposes of the Legal Practice Act and its rules. The above is notwithstanding the fact that the principal who accepts the cession will, as a result of that acceptance, have more than the maximum allowable number of candidate attorneys in his or her employment. The agreement whereby the PVT contract is ceded shall be signed by the legal representative of the attorney concerned, or by the chairperson or the executive officer of the LPC as cedent, and a certificate of such legal representative, chairperson, or executive officer containing the relevant particulars shall serve as a substitute for the affidavit of the cedent referred to in the rules. If an articles contract is for any reason cancelled, abandoned, or ceded, the principal with whom the candidate legal practitioner is serving at that time must forthwith, in writing, notify the LPC of such cancellation, abandonment, or cession. Ceding articles is not a nice experience. However, it is not a complicated process, so don't be hesitant to do it should you be miserable. Next week, we are moving on to the procedural and drafting side of things, and we'll be commencing with letters of demand. As usual, if you have a topic that you would like us to discuss, please leave a comment below. We also have a Facebook and Twitter page as mentioned, so give us a follow there too. Much love, see you next time.